Okay, good evening everyone. We are here with Richard Silver, who's going to be talking to us tonight on adjudication and taking hopefully all of your questions. Please remember to submit your questions on the chat box to me and I'll put them to Richard one at a time, which means it will be easier for him to give them his full attention. So we are recording the session, so you will be able to catch up if you missed anything, as there are no notes this evening. Other than that, I will hand straight over to Richard Silver. Richard.
Thank you, Julie. Good afternoon to you all. For those of you who don't know me, I am the senior partner of Silver Shemmings Ash. My background is in construction. I'm a chartered quantity surveyor and a chartered builder. I then moved on to become a barrister and a solicitor. I'm also a panel adjudicator on the RICS panel and the CIArb panel. Mindful of the unprecedented times we are in with the coronavirus, I thought it might be useful to give a short talk on adjudication under the current circumstances. Adjudication, for those of you who maybe don't know, was brought in to be a quick and relatively cheap procedure for dealing with disputes. The process is that a dispute must have crystallised. So far as a dispute, this can be easily defined as where one party asks for something and the other refuses, or it may be that the other party does not respond within a reasonable period of time, thereby indicating they don't agree. The simple example would be the issue of an application for payment, followed by a payment notice in a different sum. So we have to have a dispute crystallised. What then happens is one of the party issues a notice of adjudication. Within 7 days of the notice of adjudication, they must issue the referral. The referral is in effect their statement of case. Thereafter, there are further submissions, but ultimately the adjudicator has to reach his decision within 28 days or within a further 14 days if the referring party agrees, or such further period as both parties agree. Now, as you can well imagine, most adjudications are to do with money. What generally happens is one party seeks to recover money and the other party doesn't want to give it to them. Now, if you are facing an adjudication where the party has commenced those proceedings and asked for money, the easiest way of defending is to get the adjudication stopped. And one of the questions that was fairly a lot in the press is whether in the current situation with lockdown, whether it is a breach of natural justice commencing an adjudication. And this particular point arose in Milchrist Development Limited versus Walters. What happens was Walters applied for an amount of money which Milchrist refused to pay, and therefore Walters referred it to adjudication. The sum was relatively small, and the adjudicator set down a timetable. Milchrist said, no, we don't have enough time to respond to this. With the lockdown and staff not being available, we say this is a breach of natural justice and you must resign as adjudicator, and that the adjudication can only recommence when lockdown has been stopped. This was then put before the court. What had happened was the adjudicator, when faced with the challenge from Milchrist, actually proposed to extend the adjudication timetable by 14 days, but Milchrist nevertheless refused. What the court said was that Milchrist were given sufficient time to deal with the dispute. It was relatively simple. By the adjudicator agreeing to give more time, there was no breach of natural justice, and hence Walters could seek to get the decision they sought. And what I would suggest to you is, therefore, were a party to submit a final account in the form of 600 files, and then refuse to extend the period for the adjudicator's decision, thereby making sure the whole proceedings took only 28 days, and with the responding party obviously having a far shorter period, then there may be arguments of breach of natural justice. But provided the responding party is given a reasonable period of time in which to respond, provisions for adjudication, I anticipate, will be enforceable. Now, the next thing that arises, and is some of the matters that have become issues before me, is the service of documents. Quite clearly, most offices are closed, and therefore it's very difficult to issue such things as payment notices, payless notices, applications and the like. Where do you issue it? Is it compliant? Now, the starting point on that is to look at the contract. I'm going to deal with two. First of all, the NEC. The NEC says that all submissions must be in a form that can be read, copied and recorded. Fairly simple. It should cover emails, faxes, anything. They can be read, they can be copied and recorded. However, as far as those submissions are concerned, 13.2 provides that any communication has the effect when it's received. And therefore, you're in a danger when issuing something by way of email as to whether, in fact, it has actually been received. There has been issues before me where one party swears that they had sent the relevant email and the other party denies any knowledge. And it's very difficult to determine whether, in fact, it's been received. Similar problems arise under the JCT form. The JCT form provides that with regards to such matters as notices, it has to be in writing. However, 17.2 provides that the parties can agree for other means of communications being issued, by way of example, email. But any such agreement must be in writing. Now, I know all too well on many sites, the contract originally puts forward that all submissions and the like have to be in writing, but through the course of the project, slowly but surely, people send emails and they set a precedent. It's my view this would still fall foul of 1.72 because you have to put in writing that you can submit things by email. You may, however, be able to argue estoppel. Estoppel is where one party, by their actions, has indicated they no longer want to rely on a particular provision. In other words, the employer, let's say, by their conduct in paying loads of applications, has accepted that email is an appropriate way of submitting documents. So there is that possible position. But I would strongly advise you that if you are looking to issue things in a different form to what is written in the contract, by way of example, by email, you need to have it confirmed in writing. The next thing the JCT does is it does say you can issue by any other effective means. What that effectively means is that if you can prove the other party has received it, then that will be adequate. So if you're going to hand it by hand, you can show it's been issued. However, we're back into the same situation with the NEC, that if you send an email, you may have difficulty proving it has been received. Now, what I would strongly suggest that you do is you ideally want to ensure that you have a read response coming in, or some other way of proving it's come in. But if a party denies it's ever received it, then it may well be the case that you have failed to serve the notice. JCT puts another provision in its contract. It provides that where you send something by post, it is deemed received 2 business days thereafter. So that's fairly easy. You can issue, by way of an example, a notice of an adjudication in knowledge that it is deemed received 2 days thereafter. However, do be aware. Under adjudication, you have to serve the notice of adjudication before you submit your application for the appointment of an adjudicator through one of the nominating bodies. So, give you an example. You send this morning by post your notice of adjudication. It is deemed received 2 days thereafter. But this afternoon, you apply by email to the RICS for the nomination of the adjudicator. The effect is that you have applied today for the adjudicator because that's when it's been received by the RICS, but it's deemed that the notice of adjudication isn't received till 2 days later, and hence after the application. You would have therefore failed in the issue of those documents. So do be aware, if you're going to rely upon post, do not apply for the appointment of the adjudicator until the 2 business days have elapsed. Now, as is always the case, and I'm sure it will come as no surprise, in most adjudications, they relate to payment. Even when they're seeking extensions of time, is because they want loss and expense, or they want to avoid liquidated damages. So nearly all disputes relate to payment. In the current situation with the virus and things being very difficult, one thing I have noticed is that there are more old final accounts being referred to adjudication. People have found that they've got a job that finished 4 or 5 years ago, where there may be still retention being held. There may be an old final account which hasn't been settled, and therefore they resurrect that in the hope that they can get some money in. Now, as I say, I used to work in construction, and I am only too aware that many contractors believe, and for that matter employers equally, that the second moiety of retention is in fact their profit and doesn't ever need to be released. So therefore, it is all too often difficult to seek to recover that last moiety of retention. Now, under the JCT forms, what we have is we have practical completion, and upon practical completion, the first moiety of retention is to be released. We then have a defects period. That generally in most contracts is a year, and during this defects period, rectification period, the employer can notify the contractor of any defects, and the contractor is required to carry those out within a reasonable period of time. At the end, however, of the making good defect period, as I say, generally a year, the employer is then entitled to issue one list. And I repeat, one list. On that list, he can set down all the items that he believes are defects, and the contractor then has a reasonable period of time in which to rectify those defects. The problem is, it is often very difficult to get your subcontractors back to rectify those defects. It is also the case that sometimes the defects identified are not defects. They are in fact variations or works that were never your fault. Or indeed, it may be that what you carried out is compliant. As a consequence, it is quite often the case that no making good of defect certificate is issued. And the problem with that is your retention is only due to be released upon and following the issue of, amongst other things, the making good of defect certificate. So that is the first argument quite often why old retention is not being released, because A, there still remain defects in the works, and B, because the making good of defect certificate has not been issued. The next argument is that the contractor is obliged to issue to the employer or the QS sufficient particulars in support of its final account. And the PQS stroke the employer, the architect, says, well, what you've issued is woefully inadequate. The 30 files of information you provided is just not enough. So again, that is a reason why the employer QS architect then argues they are unable to issue the final certificate. And that is the very case that came before me not too long ago. Now let me deal with first of all the making good of defects. Under the JCT, it says that when the defects are made good, the certificate must be issued. What it does not say is that the making good of defects has to be by the contractor. So with the end of the defects period, if thereafter within a reasonable period of time the contractor fails to do so, he then does not have a right to rectify them. Instead, it is then imposed upon the employer to rectify them and can then seek to recover his costs from the contractor. Now, if practical completion, let's say, happened 4 years ago, the end of the making good defects period happened 3 years ago, 3 years have since passed. According to the employer, but I never have to issue the making good defect certificate because you never ever made all the defects right. That clearly was not the intention of the parties. The intention of the parties was retention would be released when the defects have been made good, and where the contractor has not made them good himself, it's when the employer has made them good. So with old final accounts, where the rectification period has elapsed and a considerable period has elapsed since then, it is my view the employer stroke architect is obliged to issue the making good of defect certificate. If he hasn't, because he hasn't made some outstanding defects good, then it is my view that they must be trivial. They aren't major. They are not sufficient to withhold the making good defect certificate, because 3 years have gone. If they don't need to be made good in that period, to me, the certificate should be issued. As far as the information to be provided by the contractor for the production of the final account, again, if a long period has elapsed, then it is my view that the architect QS is obliged to ascertain the final account based upon the information that has been provided. If you have not provided sufficient information on the value of variations, it's very simple, I value them at nil. If you haven't substantiated your loss and expense, then I make a fair assessment. So again, it is my view that if a substantial period of time has elapsed from the end of the making good of defect period, then I am of the view that the making good defect certificate should be issued, the final certificate should be issued, and therefore any retention held should be released. So if you haven't got old retentions that should have been released, I believe under those circumstances you can seek to recover them. Now, what then happens is you've got this £100,000 worth of retention that's due to you, and lo and behold, the contractor or the employer, whoever is the paying party, then says, yes, but we've got a counterclaim, and it is worth £101,000. Exactly £1,000 more than you're owed in retention. What a surprise. Now, when dealing with such matters and final accounts, I must say, on some circumstances, the information that's put before me as an adjudicator is less than good. So I'm just going to go through quickly what I would expect to see. Now, if it is the situation that for some reason, for example, there's been a termination, or for other reasons where the contract has not completed part of the measured works, it's often difficult to establish whether they're 70% complete, 80% complete, who knows? Particularly now where I am unable to go to site, and indeed even if I was to go to site, it may be the case that the works have progressed since that date. So what you ideally should be presenting is photographs. Photographs identifying the areas so that I can work out roughly the percentage of work complete. More photos, the better. We then move on to variations. The starting point is to establish as a matter of fact that they are variations. You need to show me what is in the contract, what is now required, and what the difference is, and ideally an instruction or a drawing showing that it has been instructed. But too often I don't get copies of instructions, and I'm not told what was in the original scope and what is now required. That's what you should be providing me with. What you then need to do is to move on to quantum. You need to show me how you valued these items. Too often all I see is 4 times £550. And then the other side says, no, it's 4 times £5.50. I don't know. You need to give me a breakdown. You need to ideally refer to B of Q rates and measures shown on DIN paper so that I can check them. If it is labour and materials, I'd like to see day worksheets signed. Or if they're not signed because one of the parties don't want to sign it, the fact that they've been issued. I should point out, for record purposes only means you agree to what's on that day worksheet. I remember when I was working for construction, I used to go mad at my site agents who would sign any day worksheet put in front of them, but with for record purposes only. The whole point of a day worksheet is it's for record purposes only. We know that. What you are confirming is that work was done, the hours and everything else. So if you don't agree with it, amend it. But I expect day worksheets, I expect invoices, I expect all the information to support the variation. The next one, and arguably the most difficult, is loss and expense. Starting point is generally to show that you have in fact been delayed and disrupted. But as far as the loss and expense is concerned, it should relate to the period of the delay. So what ideally I would like you to do is each month when you issue your progress reports against your program, you show where you are, which should be on program. When there is a delaying event in 1 month, you then show on your progress reports that you are 1 week behind. I can then identify what the event that has caused the delay is and what the effect on the program is. Then next month you do the same thing, and so on and so forth. Then when establishing your loss and expense, you look at the particular window where the delay had occurred and then identify the resources that were incurred at that time. What you don't do is seek to produce prolongation costs at the end of the job. The reason for that is I'll give you an example. You are doing a large external pointing job. As part of the works in the middle of the contract, you intended to have scaffold standing for 1 week, but because of lack of information, you've had to have the scaffolding standing for 4 weeks. It's not during the prolongation period, it's during the original period of the works. That is nevertheless loss and expense caused to be incurred because of delay. You can recover it. Now let's look at a different scenario. The job is 6 weeks delayed, and during the last 6 weeks, it was always your intention to have on site a finishing foreman. You've brought your finishing foreman on site on the last 6 weeks. He's not extra, he's just deferred. It's not an additional cost at all. The other thing is more often than not, at the end of the job, the resources on site reduce. So you're claiming less resources than you've actually probably incurred as a result of the delay. So your loss and expense should be based upon the period of delay caused by the relevant event for which you're claiming extensions of time. Just going to deal with one other matter, which always seems to find its way in there, is loss of overhead and profit. When you've got a job that's delayed and you're putting together a claim for loss and expense, you work out your loss and expense and it comes to £5.50. You then work out your loss of overheads and profit and it's 6 million. It's a fantastic formula, the Hudson's formula, Imley's formula, all these formulas show huge amounts of money coming to you. But no one looks at the case law dealing with loss of overheads and profit. The case says you are completely entitled to use such formulas. And indeed, many people use those formulas. However, you still need to establish you've incurred a loss. And the case where the formula was used, it was a contractor who only carried out one job at a time. So as a consequence of the job being delayed by 10 weeks, he couldn't take on another job. He showed he'd had invitations to tender, but had refused them because he was on this one job. He therefore proved that by reason of the prolongation, he'd incurred loss and expense, and as a consequence, could use the formula. So if you are a contractor seeking loss and expense for loss of overheads and profit, I would expect you to show me that during the period of prolongation, that your turnover has reduced. I would expect that you would also be showing me lots of tender opportunities that you had priced or could have priced for, but rejected. The truth of it is, in most cases, and I suggest particularly now, is if you had a job delayed and you were intending to use the people deployed on that site on another job, but because of the prolongation you can't, what you'll do is employ someone else. What you won't do is to turn away the job. And if that is the true position, you have no entitlement to loss and expense for loss of overheads and profit. Now, the other thing I pointed towards is the counterclaim. You've got your £100,000 worth of retention you're seeking to recover, and the employer says, or the contractor, whoever the paying party is, says, well, I'm sorry, I'm not going to pay you because, in fact, you owe me money. And generally, the amount of money that is owed is £1 more than the amount you're seeking. Now, when people are seeking to recover costs for defects, they have to prove that loss has actually been incurred by reason of the breach of the other party. Now, I'm going to refer you to a case I very much like. It's called Huxley Electronics versus Foresight. What happened was a contractor was employed to construct a swimming pool. The swimming pool, let's say, was going to be 30 foot long by 10 foot wide by 10 foot deep. And unfortunately, it wasn't. It was slightly shorter and not quite so deep. So the employer said, well, clearly you're in breach of contract, and therefore I'm going to contracharge you, set off against monies owed to you, the damages I've incurred by reason of this breach in the construction of the swimming pool. Now, the way he did it was he said, I'm going to work out what it would cost me to repair the swimming pool. And to repair the swimming pool, we're going to have to dig the whole thing out and redo it. So I owed you £30,000 for doing the swimming pool. To repair it will cost me £32,000. So you owe me £2,000. Clearly, that is the wrong way of assessing the loss. The person didn't want to repair it, so it did not relate to the costs of repair. It was the loss of amenity, what he had lost by the pool being slightly smaller than was required. And what did he lost? Very little. So as a consequence, all he could set off was nominal damages. So back to my scenario where the employer is seeking to set off costs against retention that is due to be released. If he is alleging defects, the first thing he must show is he's actually rectified those defects. He must then show me the cost that he has incurred, and he must also establish that those costs are reasonable. Now, no doubt when he sought to employ the contractor, he went out and got 3 quotes. I would therefore equally expect the employer to go out and get 3 quotes when he is seeking to set off money against the contractor. What often happens, and again what was before me, was a situation where the employer said, well, there's loads of defects in your works, it's very, very complicated. So what I've done is I've simply got a gang of people and I'm paying them day works. And here's the day work sheets and it says making good. And it took 3 months and here's the cost. Well, all the other party has to show is that those people were doing other works, or that the items that are being claimed as defects are not defects. then the situation is that, yes, he's claimed £8,000, but there is no way for me to establish what that cost relates to. Some of it may relate to defective works. Some of it may relate to variations. Some of it may be works that fall out with the contract. The answer is, I don't know. And on that basis, they've failed to particularise their claim. And in my view, get nothing. Okay, I'm going to do a summary now. It is my view that with the current situation that we find ourselves in, cash flow will evermore become a problem. I think there will be people who are either unable or who are unwilling to pay others. And as a consequence, there is likely to be further disputes. If lockdown continues or situations arise where there are difficulties in issuing documents, the starting point is to ensure you read the contract to find out how you are meant to issue them. If it says in writing by post, don't send it by email. But when you do send it by email, ensure you've got a read receipt. Try to establish that the other party has received it. The fact they may have chosen not to open it is irrelevant. The simple thing is, have they actually received it? Under most contracts, that is the key requirement. If you are then going to refer disputes to adjudication, be mindful, the bigger and wider the dispute, the more time that people should be afforded to deal with it, particularly in the current climate. This can easily be dealt with by agreeing an extended timetable. I've had a number of adjudications before me in the last few weeks. All of them have gone well beyond the 28 days, simply because the parties were unable to get access to witnesses, to information in the offices, and as a consequence wanted more time. It was my view, to ensure that there was no breach of natural justice, that I agreed to more time. What I didn't do, however, was to resign, despite being requested to do so. As far as I was concerned, there was sufficient time to deal with the dispute by the responding party, and therefore there was no breach of natural justice. If you are looking at old final accounts, if that final account is very old and a number of years have passed since the making good of defect certificate should have been issued, it is my view that you can still seek to recover that retention. As far as I am concerned, when such a long period has elapsed, it is the employer's failure to issue the making good defect certificates having made good those defects. As far as the account is concerned, it all goes down to the quality of the submissions. So if you're going to submit something, make sure it is fully backed up and supported. As far as counterclaims are concerned, I will view them the same way as the contractor's extension of time or the subcontractor's extension of time and loss and expense. You need to satisfy cause and effect. Global claims, as far as I'm concerned, if they can be shown to be wrong in form and therefore cannot be broken down, then the whole lot goes. Okay, I hope that's all been helpful. I have seen that there have been 2 questions, I believe. Julie?
Indeed. David's saying Waterlily v. Mackay.
Sorry, say again.
Waterlily versus Mackay, we were talking earlier about the adjudication process, which is a case I know we often reference.
And what's the question?
Was that the earlier case regarding overhead recovery?
No.
Right.
Not as far as I'm being perfectly honest. Off the top of my head, I don't believe it is, but I don't remember the specific case at the moment. If that person wants to email me, I'll happily look it up and provide it to them.
Okay, no problem at all. We had another question that had been pre-submitted by someone booking on this evening, which was The relevance of adjudication in the disruption presently experienced due to COVID-19. Can it be a better way to settle matters that will arise, and can it be promoted since it has the New York Convention to leverage on?
Okay, the first thing is you don't need to go to adjudication. You can seek to settle through negotiation. My advice is that is always the best way of dealing with disputes. And if you can avoid lawyers like me, you must be a lot better off. And even not a lot better off, you will have more money in your pocket. But the starting point is that in seeking to deal with adjudication, the reason you can go through that process is because your contract provides for it. Now, I have been involved with the RICS in recent weeks and with a number of other nominating bodies. They have sought to introduce a form of adjudication for smaller values. It is an abridged form of adjudication. It is in place to deal with what are viewed as very simple disputes under a certain value and where the adjudicator's fees are capped. As far as that process is concerned, however, as I understand it, it is not under the Housing Grants and Construction Regeneration Act. And as a consequence, the only way you can use that form of adjudication is where both parties agree. There is a further thing that Tony Bingham has sought to introduce with the RICS, which is to use their current nomination form and the provisions under standard forms, but where it is stated by the referring party that in their view, it is a very, very simple dispute. I understand the RICS will be producing a separate form where you can actually ask for this simple dispute appointment and nomination. That then goes off to those that are on the panel. And the RICS approached a number of the panel adjudicators, of which I was one, to ask if we were willing to be on this panel. And if memory serves me right, for giving a decision, the proposal is that the cost of the adjudicator is only £1,000 plus VAT. So as you can see, it is to be a very simple dispute. Where I, as adjudicator or the responding party, because of their submissions, show me that it is not a simple dispute, then I will put it back to the referring party whether they want to continue the matter or whether they wish to withdraw the adjudication. But the overall situation is you can only go through a process where you either have a legal right under the contract or a legal right under statute. So many contracts provide for arbitration or litigation, adjudication or mediation. That's what the contract provides. That's what you're entitled to use. If the contract is silent and it is a construction contract, then because of the Housing Grants, Construction and Regeneration Act, provisions for adjudication are imported and you can therefore refer a dispute to adjudication. But as far as any other process is concerned, if it does not provide for it in the contract, then you will need the agreement of the other party. Okay. Any more questions, Julie?
Yes, we have indeed. What is the limitation of liability in an event of loss?
Limitation of liability. Okay. Let's deal with it this way. Okay. You have entered into a subcontract with a party and which provides for a completion date. The subcontract, however, does not include a provision for liquidated damages, but rather provides for general damages. Nearly all subcontracts do this. And to explain the difference, liquidated damages is a genuine and reasonable pre-estimate of the loss. So it may say in the subcontract, the liquidated damages are £3,000 per week or part thereof. But most subcontracts do not do that. The reason for that is the contractor is unaware of all their costs that they're incurred, and therefore they don't want to state it before the contract or before the project starts. Instead, they're going to seek general damages, and which may include, by way of example, the liquidated damages under the main contract. So it is general damages. Now, as far as seeking the recovery of damages, there's a very old case called Hadley versus Baxendale. And what it says is that when seeking to recover losses, you have two limbs of recovery. The first is the form of loss that directly flows from the particular event that people should have been aware of. So you as the subcontractor have been on site an extra 2 weeks, which has delayed me. You will have known that I would have therefore had to keep on site my management team, my offices. You knew it. And therefore, I can quite clearly recover those costs. But there is a second limb, and the second limb is called special knowledge. And the special knowledge must have been obtained at the time the contract was entered into. In other words, the subcontractor must know at the date that he entered into the contract of the likelihood of these special losses being incurred. And one example of that is the liquidated damages under the main contract. They don't know unless you tell them. So if you are then seeking to recover the liquidated damages that you've been incurred under the main contract, you can only do it if you gave the subcontractor special knowledge. And that is why in lots of contracts you see provision that says, are there liquidated damages under the main contract? Yes. How much are they? And they put the figure in. But where your subcontract doesn't include any details of the main contract LDs, the contractor cannot recover those from the subcontractor. So in answer to the question, you have two limbs of recovery under Hadley versus Baxendale. The first is those that are direct and were in the contemplation of the parties when they entered into the contract that obviously flow. And the second limb is those that the party has special knowledge. Hope that answers your question. I think there's maybe one more.
Yep, there's Rick's abridged adjudication. What sort of value are we talking about?
Right, well, there is two separate ones. There is an adjudication which RICS is one of a number of nominating bodies that are seeking to introduce. If memory serves me right, it is capped at, and I think I remember it, it's £30,000. I'm not sure, but from memory, I think it is. And again, there is a cap on the adjudicator's fee, which I think is £3,000. But as I say, this is falling outside of the Construction Act. It is bespoke provisions that they're seeking to get people to include within their contract. From my understanding, you could not refer a dispute under those provisions unless both parties agree. The next one is what the RICS is seeking to do following Tony Bingham's suggestion. And it isn't a value. It's got nothing to do with the value. It is simply a simple dispute. Is it a simple dispute? If so, you can then apply to say this is a simple dispute. In my mind, it is the standard adjudication proceeding. So to give you an example, I have applied for payment of £30,000 fully in compliance with the contract. I've received no payment notice from the other side. I've received no payless notice from the other side, and therefore I'm entitled to the money I'm owed. Very, very simple. It may be that the amount is £1 million, but it is in theory a very, very simple argument. And provided the responding party can't come up with lots of alternative arguments, then it's a simple dispute. However, the responding party, having seen this simple case, then says, well, no, I don't think the application is valid. And they list 20 different reasons of why they think it is not valid. They then say, I did issue a response, a payless notice, but for some reason they didn't receive it. And here's all my evidence. And before I know it, it is no longer a simple event. If that is then before me, I would then go to the parties and say, I do not believe this is any longer a simple event. It is likely to take me longer than has been allowed for under this shortened abridged procedure. I therefore seek both, or more particularly the referring party's agreement, that I should nevertheless continue. Hope that helps. I can see another question I think may have come up.
It has indeed. If due to the COVID-19 pandemic, time became at large in relation to a contract, whether conditions in the contract are still valid for the reasonable time given for the contractor to complete the work?
Okay, number one, coronavirus cannot ever make time at large. Let's deal with what time at large means. Time at large means there is no completion date. So to give you an example, I enter into a JCT form of contract. It has a set completion date and it has provisions for extension of time. The reason they have provisions for extension of time is to prevent time at large, preventing the time mechanism and hence the damages mechanism from failing. So provided where the employer causes the works to be delayed, the employer grants an extension of time and time is not rendered at large. But let's say under a JCT, it provides for an extension of 6 weeks for deferred possession. But the employer doesn't defer possession by 6 weeks, he defers it by 10 weeks. According to the contract, he can only award 6 weeks extensions of time, despite the delay being caused being 10 weeks. He therefore, according to the contract, can seek damages of 4 weeks despite having caused the delay. That becomes a penalty clause. The provisions for the contract fail. Time is now rendered at large. So the reason that time has been rendered at large is because the time provision in the contract has failed because the employer has caused the delay. And that's the key point. It is the employer who's caused the delay. With the coronavirus, it's not the employer. It's nobody's fault. It is what is known as a neutral event, like, for example, the weather. And unless the contract provides for an extension of time or otherwise in regards to that event, then it falls to the contractor to take the risk. So generally, time will not be rendered at large by reason of the coronavirus because it is a neutral event.
Okay.
Oh, number 5, someone's disagreeing.
You've started something now, Richard. How about force majeure? Can this be used as part of an adjudication submittal given the COVID-19 pandemic and many sites under lockdown? Okay,
force majeure, interestingly, under the JCT has no definition. Force majeure generally means act of God. It is a neutral event. It is my view, but it hasn't gone to the court yet, that where the contract was entered into pre-knowledge of the coronavirus, neither party were aware of it, and as a consequence, I think it is likely to be a force majeure event, and hence, yes, you could go to adjudication for an extension of time for force majeure because by the coronavirus. If, however, you entered into the contract post the date that the coronavirus was known of, then I don't think it is force majeure because you knew about it before it occurred. So it's all down to timing. I do think there is also potential arguments for changes post the base date. Under the JCT, we have a base date. It's in the contract particulars. And the contract provides that where there are statutory provisions that change post the base date, they concentrate variation stroke relevant event. I think there is an argument to say that the instruction of the government potentially could be a change post the base date. Again, that hasn't yet come before me nor the courts. I now see 3 more questions. Okay, next one.
If the PC date is today and due to site visiting restrictions, the CA is unable to visit the site to ascertain that all works are complete to satisfactory standards, Can they issue PC with a caveat that is subject to satisfaction inspection once they are able to attend site?
Okay. In simple things, the parties can do what the parties agree. So you can do whatever both parties agree. The second thing is, it isn't when the person can get to site, which is the day practical completion has occurred. It is the date the works were practically complete. So if you've removed all your labour to site and he comes down to site in a week's time, the works were complete a week earlier, so he should backdate the certificate. I remember when I worked on building sites, it was not uncommon to have backdated certificates. I also know that people often say things are practically complete and then list of things of items which aren't done, which seems to sort of defeat the purpose, because if it's practically complete, there should be no patent defects. The case law says that where a PC certificate is issued, despite the fact that there are lists of defects on it, it is deemed practically complete. However, under the provision for adjudication, you can refer a dispute as to open up any certificate, and therefore a party could go to adjudication to an adjudicator like me and say, this certificate was issued on this date, we think it was wrong, these works were not complete, and therefore the certificate ought not to be issued. I should add, the NEC is slightly different. The NEC says that when you're going to certify completion, you've got to do it within a week. So in theory, they can't backdate it longer than that. And I think it's a week from memory, but I know they can't backdate it indefinitely, unlike the JCT. Any other questions?
Can the doctrine of frustration apply where force measure or argument fails?
There's the frustration. Well, the question is well, what is frustration? Frustration means that for whatever reason, the contract cannot be completed. What has been agreed cannot occur. And the one particular case, and I should remember the king, but someone hired a room to watch the coronation. But the coronation didn't go ahead. So the person who had hired the room said, it's frustrated. It's the whole purpose of the contract failed. I want my money back. And they went to court and they said the contract had not been frustrated because the person could still leave the room and have a nice day. So the whole purpose of the contract did not fail. So seeking to apply that to a particular job, if the whole site is burned down, then I would suggest there is possibly frustration of M. As far as force majeure coronavirus, I can't see how the agreement would ever be frustrated because you will be able to start at some time in the future. The simple issue is who is going to take responsibility for the delay and the additional cost. I don't believe there will be a frustration event.
Okay, and the final question that's sitting there so far, can COVID-19 be treated as a variation leading to an extension of time based on replanning of ongoing site activities to maintain, for instance, social distancing?
Simply no, because it's not a variation. If one looks at the contract, JCT by way of example, it actually states what constitutes a variation, lists it all out. Change of this, change of that, change of other. It doesn't include coronavirus. So unless you can show there has been a change by reason of instruction associated with the requirement of the employer that is not to do with coronavirus, then I think it's a difficulty to get it as a variation. I think it could be a variation where, for example, you believe that you have a right to go back to site because the nature of the works you've undertaken aren't required to be stopped by reason of the current position. So let's say you were working in a hospital that deals with patients, your work is really, really important. It isn't excluded, it's not subject to the lockdown provisions. Therefore, and it wouldn't happen, but were you then told you cannot go back, then as a consequence, I don't think it's because of coronavirus, but a different reason, you could then have a variation. So the only way of getting it to a variation is to show that whatever you've been instructed to do is not because of the coronavirus or government requirements, but is another reason, which is the sole request of the employing party.
Okay, and another one, could you please briefly describe the difference between loss and damage?
In very simple terms, there isn't any. What you have is, under most contracts, let's give an example, JCT, it provides for loss and expense. Loss and expense, therefore, is an entitlement you are recovering under the express terms of the contract. It actually says it's to be ascertained by the PQS, and it's going to be assessed in a certain way. So it is a recovery under the contract provisions to be ascertained by the CA/the QS. If you then go to JCT, it says your common law rights are retained. And your common law rights are damages for breach. So damages are your losses that have been incurred by reason of breach of contract, and you would not get the PQS assessing it. It would be someone else outside of the contract, because you are alleging breach. You're not relying upon the provisions of the contract. You are instead relying upon your common law rights. You may, for example, seeking tortious actions, which is a failure of a duty. Now, the general rule is most people should be advised to recover loss and expense under the express provisions of the contract. Your recovery will be much greater. The reason why people seek to recover damages rather than loss and expense is because they've failed to follow the provisions of the contract, particularly with regards to notices. So if there is a position that, for example, you must issue certain notices to be entitled to recover loss and expense, but fail to do so, you may have an alternative argument for damages for breach, depending upon how the contract is written. But very simply, damages is for breach under the common law, loss and expense is under the contract and the provisions therein.
Brilliant. Okay, that's fantastic. Thank you. And I'm sure if anyone's got any more in-depth questions, they will quite happily email you to Richard Silver at silverllp.com. This will be up on the website shortly for people just to re-reference. And I believe your next one is on the 4th of June. And your hot topic of the day then will be termination. So
yeah, I'll be dealing with termination, repudiation, and what you can and cannot do. Again, it's something that's come before me quite a lot recently, with people looking to get out of contracts because they no longer want to carry them out, or others looking to terminate someone and employ someone else. It is a very tricky area, and in my view, very interesting. You may not agree. Thank you everybody for listening. I hope you all found it interesting. I think there's been one more question.
Brilliant. No, let's just say thank you very much. A golden session. They've gathered many things, so there are lots of thank yous now. Thank you very much for your time, and thank you everyone for turning up tonight, and please stay safe. We'll see you all back online soon. Thanks
everybody.